A terrorist organization includes the terrorists, their field commanders, and their senior commanders. A fight against terror requires striking at those who lead it. When the chief of a terror organization is executed, is that a murder? What if his death means that an attack on innocent lives is prevented or postponed? Some say that a terrorist leader should not be treated like a common terrorist, but should be captured and put on trial. In the war against terror, where does the battlefield end? And where should the courtroom take over?
Good opening, good morning, and welcome to the lovely targeted killing session. My name is Dudi Segal. I'm the diplomatic correspondent for Israel Channel 2, and our panel subject is targeted killing between the laws of war and criminal law. Osama bin Laden was killed away from the conventional battlefield. He and others like him, leadership figures, but not distinct military commanders, legitimate military target, or must they be arrested and provided legal due process? This dilemma will be the heart of our discussion. Our distinguished panel includes Lieutenant General David Fridovich, former Deputy Commander of the U.S. Special Operations Command, Professor Richard B. Jackson, a professor of Georgetown University Law Center and Special Assistant to the U.S. Army Judge Advocate General for Law of War Matters, and Advocate Pnina Shavit Baruch, former head of the IDF International Law Unit. Welcome to all of our panelists. We will try to figure out in the coming minutes how close is a targeted killing to an effective murder. How effective it anyway? Is the goal, is in a military-wise and strategic-wise, is the price is good enough for this cause? I know what you did last summer, especially the Israeli one of you. You were watching on TV or being in reserve in another operation in Gaza, and it was only 3 years after a successful targeted killing of Ahmed Jabari, who was the head chief of staff, so-called, of Hamas, that started the last operational pillar of defense. How much a targeted killing can really change the operational field, and how much do we need to invest in it? I will try to start dealing with that with Pnina Shavit Baruch, that will give us the Israeli point of view and the development that has been made during the changing condition of war, mainly against terror. Pnina.
Okay. So, try to be brief. Well, the question that you asked of what role does it play? Should it be carried out? Its implications is, of course, not a legal question. And, of course, when we come to targeted killings, there's a lot of non-legal considerations, which I will not refer to, but we have to bear that in mind. Not everything that is legal is necessarily clever. Should be done, so there are other considerations, too. I will try to speak briefly about the development of the concept of targeted killing in the IDF and in the international arena, and there is a link between the two. And in this, I will try to refer to both the heading of this panel, which is targeted killing between the laws of war and criminal law, and to the heading of the conference, towards a new law of war. Because I think that the way targeted killing, the concept of targeted killing was developed and continues to be developed, exemplifies the way in which, in my view, the laws of armed conflict or the laws of war develop and should be developed. In 2000, the end of 2000, as we all know here, what is now termed the Second Intifada, we tried to find a different name, I remember in the IDF, didn't succeed, broke out, and in the beginning of 2001, and then it went on, of course, 2002 and 2003, and we were facing situation that was very violent, very high levels of violence, We had many casualties. We had the use of weapons. We had areas after the interim agreement or the Oslo agreements, we had areas that Israel withdrew from or redeployed its forces from, and the forces were not going into those areas, and those areas were controlled by, or they were in these areas, Palestinian organized forces of the Palestinian Authority. We had organized or semi-organized forces of different terrorist organizations, the Hamas, the Islamic Jihad. This was the background. We had violent clashes on a daily basis. And in this background, I think it was the beginning of 2001, the commander calls us, the legal advisors that are in the International Law Department in the IDF, and says, look, we have very good intelligence of the whereabouts of where one of the senior commanders of the Hamas is. It's in the middle of a town in an area that we are not, the IDF is not operating there. We cannot enter and arrest him. If we try to do that, we won't succeed. It will cost a lot of lives, but even apart from the lives, we just won't succeed getting there. By the time we get to where he is, he won't be there anymore. But we do have the ability to target him from the air. And we can do it in an accurate way. Civilians also won't be necessarily killed. We can do it in a way that won't affect others. Can we do it legally? And now we have to give our legal opinion. In previous wars, not talking only about the Six-Day War and Yom Kippur War, even in the first Lebanon War, legal advisors were not involved in operational decisions. But here, this was a different situation because we were controlling the area for a long time, and the whole operation of the IDF in the West Bank, in the Gaza Strip, since 1967 was carried out under a rationale of a military government, of the laws of belligerent occupation, of the laws of occupation, the Hague regulations, the Geneva Convention, without talking now about the Euro applicability, but the de facto applicability. We had the first Intifada, we operated there were rules of engagement, there was a rationale. The rationale was a rationale of law enforcement all the years, and in that kind of rationale, you have legal advisors involved all the time, you have High Court of Justice involvement. So they were used to asking us these questions, and suddenly they asked this question, and now we have to give an answer. And the answer depends on the definition of the situation. So the first question we had to ask ourselves is, what is the situation? And there are two main answers. The one is, this is a law enforcement situation, and the other is, this is an armed conflict situation. Now, the difference between these two is crucial for this question, because under a law enforcement rationale, you can arrest someone, you can use force in order to affect the arrest, you can use force in cases of self-defense or to disperse a crowd sometimes, but that's very limited force. You're not allowed to go and target a criminal. You're supposed to arrest that person. Under a rationale of armed conflict, it's a completely different rationale. You are allowed to kill the soldiers of the enemy, and the soldiers is actually the armed forces of the enemy. It is even what you are supposed to do under the rationale of war. It is lawful to target with the intention of killing the combatants of the other side, and also, in certain cases, also civilians if they are directly participating in hostilities. I'll come back to that point in a moment. So the definition was crucial to give an answer. Now, it wasn't an easy answer to give, because at that time, the whole concept of what kind of measures can you use against non-state actors, against organizations, against terror organizations. The prevailing view was that terrorists are criminals, and the way to deal with terrorists, as with other criminals, is through law enforcement, and not through an armed conflict rationale. There was not much literature as other options, but we viewed we looked at the law, we looked at the relevant treaties, interpretations of treaties, we looked at the practice of other countries, we looked at the history, we looked at the literature, and we concluded that in this situation, because of the circumstances that I detailed before, this is not a law enforcement situation because when you have an area that is outside your effective control, you cannot really act there. The level of violence is so high. There is an organization there. There is a use of force that is above a certain level. This could be defined as an armed conflict. We found precedents for it, and we said, okay, we think that this is an armed conflict situation, and therefore the laws of armed conflict will apply, and not the laws and not the law enforcement rationale. This was criticized. We got criticism even from the US at the time. This is prior to 9/11. But we went ahead with this position, and under this position, then the whole issue of arresting is not the relevant issue. Now you have, under the law, under the armed conflict rationale, as I said, you are allowed to kill in certain situations, and whom are you allowed to kill? Now you have, there are rules. The rules are derived from the principle of distinction, the principle of proportionality, known principles in the laws of armed conflict. Now, was there a rule saying, can you target a certain person in this way? No, there was no specific rule, but the law in general, and especially the laws of armed conflict, or international law in general, especially the laws of armed conflict, don't work that way. You don't have to have specific rules in order to have a specific authority. You have a general framework, you have principles, you have certain rules, and you derive from them and you apply them to the situation. So we said, okay, we have the principle of distinction. Under this principle, it is lawful to target the armed forces of the other side. Can we see the commander of the arm of an organization that we are fighting? And I don't call it a terrorist organization on purpose. I think when we speak about armed conflict and terrorism and fighting terrorism, we are actually then combining the two concepts and confusing the discussion. So once I'm in an armed conflict situation, I don't care if the other side, what it's called, it's a terrorist, it's an organized armed group, which is not a terrorist organization. The thing is, who is my enemy and who are his armed forces? If my enemy, this is my enemy, and these are his armed forces, then that's what's relevant for me to apply the laws, to apply the issue of distinction. So who are the armed forces? And we believe that in such a conflict, when we are fighting such organizations, the members of the organized armed group are the armed forces of the other side, including their commanders. And therefore, we can view that person as a combatant. When I came to the commanders and I said, yes, we believe that they are combatants, they almost killed me. They said, combatants, they are terrorists. I said, I'm not giving them a compliment. This is just a legal definition of who is targetable and who is not. So these are the combatants of the other side, and therefore they are targetable. And this was our initial position. Then we had a petition to the High Court of Justice, and this was the position of the government. The High Court of Justice, in the famous targeted killing case, was reluctant to take this position. As I said, this is prior to 9/11, very little literature. They looked at the wording of the article, of the treaty, and also the situation, the factual situation. The organization of the Hamas was not as it is today. And they said, we don't think, you're trying to create, you, the state, are trying to create a third kind of between combatants and civilians, something like unlawful combatants. This is a new category, it doesn't exist in law. They didn't accept this position. But they did accept our alternative position, which was, even if you don't see them as the combatants of the other side, then you have another rule in the laws of armed conflict, which says that civilians, in general, civilians have the protection. As I said, you're allowed to target and kill combatants. You are not allowed to target and kill civilians. But there is an exception. If civilians who directly participate in hostilities, when they do that, for such time as they are directly participating in hostilities, they lose this protection and you can't target them. So we said, okay, even if you don't see them as the armed forces of the other side, then you should see them as civilians directly participating in hostilities. And the court accepted this position and said, yes, a commander that is anyone who is involved in instigating, organizing, carrying out terrorist, these kinds of terrorist actions is directly participating in hostilities. they still had to find a solution for the issue of for such time as that person is involved in hostilities. The High Court of Justice here said, we accept that it's not just when you know that that person is at this moment sitting and planning the next terrorist attack. If this person is involved in the organization, that's what he does, even if in other times of the day he's sitting and selling shoes, but in the evening he's planning terrorist attacks, he has lost his protection, his immunity from attack for the whole time that he is part of this organization. So you can attack him even when he's not at that moment involved in planning the terrorist attack. And this is the targeted killing case that gave us the basis for our targeted killing, for using this tool. Now, this case became a central case also in the international world. And the international arena, it is quoted around the world. It is known by all international lawyers that deal with laws of armed conflict, and it serves the basis also in other countries. What happened the next stage, and how much do I have, 1 minute, 2 minutes? The next stage, though, is that after 9/11, other countries, mainly the US, also understood that they have similar kinds of dilemmas. They have a way to target from the air senior terrorists and no option to go in and arrest them. This became something that was being carried out also by the US and others, mainly the US, but others too accepted that this is a tool that is necessary. And what happened in the international arena is that the ICRC, the International Committee of the Red Cross, which is a Swiss organization but is responsible, among other things, to develop the laws of war, the laws of armed conflict, they convened an expert committee. It was more than once. They convened a group of experts who sat for 4 or 5 rounds of discussion. I was one of this group. To discuss the whole notion of direct participation in hostilities and the whole issue of what do we do with these kinds of new actors that we have. They're not so new, but the legal debate was relatively new, and they came to a very interesting conclusion. And the one is that when your enemy is a non-state actor, and that non-state actor has an organized armed group, the members of that group, at least those that have a continuous combat function, there's a bit of discussion, what does that include and what is that definition, but still they accepted that part of this, those that are members of this organized armed group that are involved in combat are considered the armed forces of the other side. They are not civilians, they are combatants. So they actually accepted our initial position of the government, that the court didn't go that way. It would have, I think, if it had already the interpretive guidance then. And this was really a breakthrough, because in the first round of this expert meeting, that was not accepted. Only from the second round on, this notion was accepted. And it was a development of the existing principles. They looked at the principles, they said, let's apply it. This is the relevant, this is the right application. This is the logical application. Still, there are many discussions about who enters into it, and they still also continue to discuss the DPH, the other civilians directly participating in hostility, and what does that mean. My point, and I will end with that, is that now, after a few years since also this interpretive guidance and a lot of literature written about it, today the concept that you have armed forces of a non-state actor is acknowledged by most of the scholars. The legality of targeted killing as such was recently upheld even by a rapporteur of the UN. So today most relevant scholars accept the legality of targeted killing. There are still questions about proportionality. There are still here and there questions of who exactly is considered directly participating in hostilities. But the way that this was developed was through a development of the existing legal framework and applying it to the relevant circumstances. This, I think, is the right way to develop the law. The law is a customary law. The international law is a living thing. And I think that the other option, and I'm sure there will maybe be questions about it, of going and saying there's no relevant law, let's have a new convention, a new treaty on the laws of armed conflict, is, I think, a little bit naive, because there's no chance that there will be a new treaty that will give militaries more freedom of action. So any treaty will just have more limitations.
Thank you very much. We'll go back to you and try to explore what should be the next step. Professor Jackson, I would like to ask you, do you agree with Mr. Baruch Sharvit that Israel, in a way, paved the way for a new rules or new conditions, legal condition of targeted killing? And what are the key differences between the Israeli approach and the American one?
Thank you. I guess the answer is yes to the first, but I'll try to explain the different approaches to us for us with regard to this issue. First of all, I'd like to say, though, it's a privilege for me to be on the panel with these distinguished people. General Friedovich and I started out as colonels together at U.S. Army Special Operations Command, and he's done quite well for himself since then. I retired as a colonel. And Penina and I got to know each other when she first gave the most amazing description of the IDF application of the law of armed conflict to the last Lebanon war that just completely illuminated both the challenges for the IDF, but also the compliance with the law of armed conflict that they demonstrated in the context of that war. I'd also like to start out by saying I hate those cartoons, okay? You know, because, and the answer to the questions on the cartoon is yes. Okay, so we don't have to say anything else. But the cartoons are oversimplify things. And it's to be provocative, I understand that, but there's a lot more to it. First of all, we don't like the term targeted killings. Would an untargeted killing make sense? Wouldn't it become a indiscriminate targeting? So we talked about targeting in armed conflict rather than targeted killings. There's this connotation maybe of assassination when you use the term targeted killing, and it probably was a choice by the plaintiffs in the lawsuit in order to stir things up. I'm sorry, I didn't catch that. Oh, it's just words. Yeah, words, and it's lawfare from my perspective to use that term in that way. But our analysis of the issue is very much the same. What I'd like to do is talk about really two contexts for targeting in hostilities. First is in areas where there are active hostilities, where there's a war zone. And second, in areas outside of active hostilities. Now, I don't really care much for that term either, because I think, at least with regards to the U.S., we're in an armed conflict with Al-Qaeda and associated forces. But our policies that have been, the U.S. policies that have been talked about by the President, Brennan, by the Attorney General, by two legal advisors or general counsels for Department of Defense, they all start from this premise that there's a difference between how we target combatants in areas of active hostilities and outside them. In areas of active hostilities, we target members of the organized armed group with whom we are at war. Well, how do we know they're members? The much anticipated Law of War Manual, U.S. Law of War Manual, is due out shortly, and it, for the first time, explains what at least the U.S. Department of Defense's view is with regard to the direct participation hostilities concept that Penina talked about. And it recognizes, this manual recognizes that we target members of the enemy opposition. Now, that's implicit in Additional Protocol 2. If you read the commentary, for example, to Article 13 of Additional Protocol 2, it talks about, the commentary talks about distinguishing between civilians and combatants. So, and Additional Protocol 2 for non-international armed conflict talks about parties to the conflict and the organized armed group, and so it wouldn't make any sense to have a conflict between civilians and a state. It's really a conflict between a state and this organized armed group. In fact, that organized armed group under Additional Protocol 2 has to be so organized that it can conduct sustain military operations. That's not a bunch of random civilians. That's a group that's led by a leader like the one on the slide and has subordinate commanders and gives orders that sometimes don't comply with the law of armed conflict, or quite frequently don't comply. So how do we know if you're a member? We use the test, an actual or functional membership test. We also adopt some language from our domestic habeas cases that have defined the authorization for use of military force, or our declaration of war, based on its definition of Al-Qaeda and associated forces. And so we focus on whether or not they're actually a member of that organization. They're a card-carrying member, if you will. They've been indoctrinated and trained by that organization, or are they performing a function that's vital to that organization? And instead of using this calculus that the ICRC interpretive guidance came up with of A plus B plus C, we use more of a totality of the circumstances test to determine that. So the leader certainly fits in that test. Now there's a wrinkle that the ICRC added that Panina didn't talk about, and that is part of the bargain within the ICRC's interpretive guidance was to add the requirement that if you're going to target a member of the organized armed group, that they be performing a continuous combat function. So there might be some debate from some human rights lawyers and maybe some folks from the ICRC about the difference between the folks carrying the arms and the folks giving orders, but probably not. The interpretive guidance itself says that leadership is certainly a member and directly participating in hostilities and performing a continuous combat function. But there's a lot of debate about other members of the organized armed group and the function they're performing. And so we don't comply with or have the same analysis as the interpretive guidance with regard to what function they're performing. So people that are the trainers or providing direct financial support to the people on the ground, they're carrying money from Qatar to Afghanistan, and then they're the paymaster for the organization. Those are also valid military targets. Now, we prepare what you call a high-value target list. Now, so what I'm referring to is our deliberate targeting in areas of active hostilities. And what we do is we analyze at a very high level within the organization, the Joint Task Force level, the Special Operations Task Force level. We evaluate the function that individual's performing and to determine whether or not they're a part of the organization. And then, and we use that, a great deal of intelligence, a great deal of sorted and multi-faceted intelligence to determine that. Now, we also employ, I mentioned the speeches about policy limitations on attacks outside of active combat areas. So this is were we to be involved in the non-international armed conflict going on in Yemen, for example, we would apply these standards. Now, I'm not going to talk about the use ad bellum issues, how you get to the battlefield itself, but I'm talking about the use in bello issues. How do we determine whether or not it's a valid target in areas like that? Now, there's been additional requirements that are not based on the use in bello. There's a necessity requirement put into that targeting. Is there a law enforcement alternative? Is that necessity requirement? So is it an area where the nation itself is unwilling or unable to actually engage in that target, which is a use ad bellum issue. It's an issue that is applied to the law of national self-defense. There's a a requirement, and President Obama's talked about this many times, including with regard to the 2 American hostages that were killed a couple of weeks ago, a 0 civilian casualties anticipated. Now, we've talked about the proportionality standard. That's an unreasonably high targeting standard, and it would not be required within an active area of hostilities, but it's one that's been imposed on our forces in deciding who is on that list. There's one other context that we could be using force and targeting, and that is the context of a transition between an active hostilities to sovereign governance by the state itself. And that's the example of Iraq. And in Iraq, some of my colleagues in the Special Forces community, attorneys in the Special Forces community, worked with the Iraqi counter-terrorist elements to develop a concept that became the concept for the entire nation of Iraq and then was migrated to Afghanistan, and that is the warrant-based targeting concept. Now, using stone-hard killers like SF folks to essentially deliver a warrant to the bad guy is pretty strange and unusual. But it was an important technique that was developed in order to transition during a period of occupation from the right to use force as a national self-defense concept or in war to a use of force in where there's domestic sovereign authority involved. And I'll close there.
All right. Let's take it to the field. Lieutenant General Fredovich, isn't targeted killing is maybe a way for leaders and commanders to say that they do not trust the legal system? You know, it's too much of a headache to take someone from his home, to take him to a trial, to prove it, and then to trial him. And this is the easy way to make justice with the bad guys. And you were appointed in 2010 the Special Operation Command, Deputy Special Operation Command, and you were aware of what happened to Osama bin Laden. Osama bin Laden was, by all means, the head of a terrorist organization, but in the time he was targeted, he was in Pakistan, outside the battlefield. And do you think it was a justified action by the laws of war? By the way, if we will make a poll here, you get 100% yes. But
I've said many times that I believe certain men have earned the right to die. And I've said that several times recently to meetings and conferences in the United States. It's probably the first time I got a round of applause, but that's fine. And I don't say it for shock value, but I think what it says from my brain and my heart to you all is that I take this extremely seriously, and that yes, you have to have men that I've led and maybe men like me that are willing to do. Okay, you earned your money. Yeah, that are willing to do this work. The two explanations that were given and the format by which they were given kind of put me right where I'm supposed to be in the middle, to say that by the time I get it from Colonel Jackson and others, I know we're ready to go. One of the things that matured over time was that we would go into targets, and this is where I think the warranted killings were, the warrant deliveries were so important. We would go into environments and we would control those environments so severely and so specifically that our loss rate was very, very low. And actually, by the time I was working as the vice commander in Special Operations Command, I worked, and about once a week we would go and have a counterterror meeting in the White House or other places, and we would go over the high-value target list and to see if we were going to, or if one of our operational headquarters was going to conduct a target. And it was really, it wasn't pro forma. I mean, people really, had studied it, and they'd come, and everybody was tied in around the world via secure video teleconference, very, very matured process. And really went around the room, and the FBI was there, the Department of Justice was there, all the executive branch, and certainly a few other members, but rarely was there any objections. And tactically, the commander of one of the task forces forward was there to say, yes, we're ready to go. The only time there was any real questions, and it wasn't a matter of should this person or should these people be targeted, it was, how can we make, and this is critical, how can we make positive identification? What are the characteristics, traits, attributes of positive identification that by a variety of intelligence means and sources, cross cues, as we would say in the intelligence world, that between signals intelligence, other communications intelligence, certainly drones and direct observation, that you have what you need to say that these are the people, and even by association at a certain point, you're going to accept some collateral damage, collateral fatality, but even that was rarely talked about. It was, were there any objections politically? Do we have the right? And I also think Pakistan, for whatever purposes, was outside the combat zone, but it was still, there were programs there that were in fact, part of the program. So they tried to take out some of the sanctuaries and some of the places where support was being worked on. So by the time we got it, we rarely challenged, the efficacy of the laws. It was already there in a nice, neat package that we said, okay, and then it's a matter of, do we have everything we need to be successful on the mission?
But on this mission, were you giving your guys on the field, the Navy SEALs, a command saying, get him dead or alive, but also alive? Was it?
No. Every mission was a C/K, which in the parlance was capture, kill. They had that option, and every time they went in, they rehearsed for both missions to include rendition and to include what they would do if the guy didn't pick up a weapon. And as soon as he picks up a weapon and tries to defend himself, he'd become a combatant. If he decided not to do that, he's going to be taken in.
And what happened with Osama bin Laden?
He picked up a weapon. He made a choice. And at that point, he became a combatant. Again, like I said earlier in the panel on our rules of engagement, you don't want the people hesitating. They read it, they saw it, and it was instantaneous. They were trained to go ahead and shoot him twice, and they did, or more.
And do you think...
But I think there's a bigger question. I think you might have alluded to it, or both of you, all of you did. What's the outcome of doing this? Does it have a real effect? Going after Osama bin Laden, we said, Bush said he was going to do it, didn't get to do it. It was, the intelligence timed it, pretty close to the U.S. election. But just the same, not playing politics, it happened. He said he was going to do it, though.
Right.
So, and if he didn't get it done, I think that the next president, whoever he or she might be in America, would still continue the hunt. So, at the end of the day, what effect did it have short of the politics? And that's for anybody to answer. It's just kind of my question to you. How about that?
No, maybe I'll ask that to you. I think that there's the question about the effectiveness of killing leaders, because we see in Lebanon, for example, in the Israeli experience, after we killed the last head of Hezbollah, we got the worst head of Hezbollah. So people will say, if you wouldn't killed him, you'll got a much bigger Hezbollah. So I'm asking you, as a commander-in-chief, as someone that was on the battlefield, how effective do you think it is? Do you think there's a targeted killing? And I'm even go maybe further. If Israel got a chance, for example, to wipe out Hezbollah leadership in one bomb that will kill 200 people in a day, on a clear day, with no provocation, but maybe will save the lives of thousands in the next armed conflict with Lebanon, is it an operational and illegal choice Israel should take into consideration?
I would think that you would want to consider that, sure. But that's the picture you painted. That's the picture you painted. That's kind of a, very rhetorical, but good on you, as we'd say. But like you said, I always wondered, and I didn't come to this country until about, I want to say 2003 on a capstone program. And it was one of those, changing experiences as we all have when we come to Israel for the first and many times after that. But I always wondered why, and I really only got to ask it yesterday, why wasn't, maybe Arafat was targeted, but I always wondered why. And maybe it was because it was better the devil you know than the devil you don't know, which is your point about Hezbollah. I don't know. This is where, the local intelligence and information is much better.
I have to remind you that President George W. Bush, when Israel first got into 100 meters into Gaza, said, get out of there right now. So I wouldn't imagine that the United States would have praised Israel for targeted killing Arafat back then.
I'd like to make one practical point, though, with regard to this. And this is, when you're dealing with a clandestine organization, one important factor in this capture or kill discussion is, can you capture him and help roll up the organization? So there's some value in capturing and talking to my special forces friends. That's one reason why they always make the capture kill distinction, because if you can capture them and General McChrystal really demonstrated this in running the Special Operations Task Force in Iraq, and tried to teach that to the Iraqis, which was, you focus on the leaders of that organization. Well, actually, you focus on the low level leaders in the organization and work your way up, and you can't do that if they're dead.
Mm-hmm. Attorney Shavit Baruch, I would like to ask you, let's go back to the hypothetical decision making. If the Prime Minister of Israel would tell you, in the next round of conflict with Lebanon, I would like the outcome to be that in the first day, even before one shot has been made, the entire Hezbollah leadership is wiped out. Can you make it legal? Can you?
It's there's no question type of a question. When the leadership of let's start with the military leadership, the commanders are lawful targets. You can kill them one by one, all of them together. There's no issue about their targetability. There's still the issue of the proportionality with regard to civilians. I will touch in a second, but I want to go about the targets themselves. So of course, anybody who is involved in the military aspect is a lawful target for sure. But more than that, also the leadership, and it goes, by the way, both ways. The leadership, the political leadership that is also involved in the decision-making that is to do with making decisions that are of the way the armed forces operate is also targetable. It goes both ways, meaning that in our case, the Minister of Defense is also a lawful target for enemies, okay? If I'm talking, or the President of the United States or our Prime Minister, anybody who is involved, even if they are civilians, this is I think almost there's no real dispute about that those kinds
of
leaders, it is legal.
Right.
The problems usually arise with regard to spiritual leaders or to leaders that are or to people in the leadership that are not involved in the military, in giving instructions to the military, and can they, no? Yeah. This is the way, okay. Yep. And can they be targeted or not? And here again, here you have different opinions, but those again that say if there is enough of a link to the military decisions, then they could be, and we had the call question with Sheikh Yassin. Sheikh Yassin wasn't just a spiritual leader, he was also involved in decision-making with regard to terror attacks, so that, again, made him a lawful target, not because of his spiritual leadership. So that's with regard to the targets themselves. Then there still is the question of the proportionality, because as the whole issue of who's the lawful target and who is not, that's the principle of distinction. You always also have to check the principle of proportionality, and there you have to check what would be the impact of the two civilians that are not targetable, those that are not considered directly participating in hostilities.
Like to keep on with
Yes.
Lieutenant Friedovich question to me and me back to him, to you, how is someone who've done it, been there in the operational room when you needed to take decision on legal matters regarding targeted killing, how effective it is?
How effective is the targeted killing? So I think then, of course, these are already not legal considerations, because as I said, the legal consideration is the beginning. It's not the end of the story. It's one element that has to be, you have to have it has to be a lawful target, but then you have a lot of considerations. There have been many cases where names were raised, and eventually there was a decision not to go ahead and target the person because of the repercussions, because of the possibility of retaliation that might deteriorate the situation. So you have a lot of considerations. You have many times different opinions within the room. Jewry, I wasn't there, this was after I left, but I presume that some said it's a good idea because we will get out a very important element and this will impact their capability to carry out attacks, and maybe there was something more specific that was planned or not, I don't know. And others maybe would have said, no, now at the moment the situation is calm, if we do that it might deteriorate the situation, maybe it's not, we don't want at the moment another higher level of clash, and we should take that into account. And these are the relevant considerations that you expect them to take and to make eventually, hopefully, the decision that each alternative has its pluses and its minuses, and you have to do the balancing as in any decision, operational decision.
I would like to ask all the three members of the panels, I will start with you, Mr. Jackson. How much do you think are the lawyers or the laws are a burden to the operational units, to the army, in order to fight terror these days? And what can be done to make it more effective to fight this kind of combat that became very known in the last years, that the enemy is not very clear, it's part of the population. All the old language of the war laws doesn't really apply on terror from the inside of population. We've seen it here a lot. You've faced it in Iraq and Afghanistan and in other countries.
Well, in terms of the role of the lawyer, that question's better addressed to a former commander, but I always tried to be an operational attorney, which is assist the commander in making decisions by providing legal advice and not make the decision for the commander. And no good commander would let me make the decision for him. But to provide ways to accomplish the mission legally rather than be an obstacle to the conduct of the mission. And there are some times at which I gave advice to a commander that they rejected, and they took that on themselves, and that was, and I understood that. But it's the commander who faces the consequences of that, not the lawyer. It's very much like when I was a defense attorney and stood up and the judge said, you know, you're condemned to 7 years in jail. I wasn't going to jail with the defense attorney, so with the defendant. So I told that to some of my commanders on occasion.
Lieutenant General Friedovich.
The conversation that Colonel Jackson and I would have as a commander and to an operational lawyer is just what he said. I would sit down, and first thing I would say is, you know, I love the law, I respect the law, I admire the law, and I admire lawyers, and I mean that. And you know, and I'm not pandering here. This is the conversation I would have, and I say, the more senior I get, the more I understand the necessity for my success is to have an operational lawyer that understands what I want to achieve. Now, just as he said, I would probably get out ahead of him and say, look, I'm asking you to be creative. Create a box that I can operate inside of. I will not ask you to give me something that's going to put me outside the box, which puts me outside the law. I'm not going to do that. So we're not going to have that kind of tension, but I need you to get creative and listen to what I want to do. And I fully understand that when I go against your logic and your legal mind, I'm the one assuming the risk. And I had a conversation last night where, I brought up the point that quite often in the policy realm, lawyers, not the ones that are working directly for you, but the ones that are in a senior headquarters above you, there's always one or two, where you say, look, I want to do this. And my lawyer would say, hey, sir, you're good to go, except the admiral's lawyer says, no, we don't see it that way. I said, okay, what's the deal? And the deal would be, I want to do something that's not expressly prohibited. So if it's not expressly prohibited, I think I can do it. My lawyer, operational lawyer, says that's correct. Nothing says you can't do it, but they say there's too much risk involved, or they don't see it that way. I said, tell me where the prohibition is in writing, bring it to me, bring that lawyer down to me. Have him convince, or her convince me that I want to do something operationally that's not prohibited. So if I'm not breaking the laws morally, ethically, legally, I'm not breaking the law. Show me where I am. If they couldn't do that, then I would say, I would thank them, and I would say, it's now between myself and that commander. Does your commander know that we're having this conversation? Quite often not. And I would go to the commander, because commanders can speak to commanders. That's the way it works. And good operational lawyers know that. He's given me his best advice. I'm going up there to fight the fight that I want to achieve what I want to achieve, which is not different than what the admiral wants me to do. So I go and speak to the admiral, come back, and I have my decision. I might not have made a friend of that lawyer beneath working for the admiral, but I really don't care. This is my operational attorney. He's given me his best shot. I'm the one who's going to accept the risk. I'm going to tell my boss I'm doing it. If he tells me not to, that's who I'm listening to. If he says good, or there is a prohibition that I don't understand, I'll be educated in that way. That's the way I functioned from the time I was a lieutenant colonel to the time I was a deputy commander at 3-4-star level. So that's the way it works. And you have to set the environment and the tone, and your lawyer has to know, your operational attorney has to know to be able to come to you and say, sir, before you go any further, consider these things.
Can you give us an example?
I did yesterday in the speech, but I don't want to rehash that one again. But it was clearly, that was different. That's where I actually assumed the role of the guy who said, hey, sir, you don't want to do this because you shouldn't. You can, but you shouldn't. And that was clearly accepted. But then we found a creative way to achieve, and this has to do with targeted killing. The men that we went after with the Philippine Armed Forces were on a targeted list. So that all kind of brings it back right here that we did it through, by, and with another nation's rules and laws in force. We did not do it. Now, I will tell you the FBI did help us with the DNA to say, yep, the guy who we thought died of wounds, in fact, was a guy on the list, and that started to shut down the Abu Sayyaf group in the Philippines. So yes, it works. But it took 2 years to get there. So what we asked for more than anything else was strategic patience, like I said yesterday, from the commander. So yeah, it works. But you have to have, the right legal guidance. I'm not a legal mind. I'm not a legal scholar. I rely on them to be successful.
I just wanted to add one point to that, and that is it's important for the operational lawyer to separate legal advice from policy advice and make it clear that the policy advice is just that, and that he can reject it. But quite frequently, the operational lawyer gets to know the commander so well that he or she is the only person in the headquarters that would say no to a commander. But that's a matter of personalities and getting to know and be trusted by your commander.
That relationship.
Attorney Baruch, can you tell us about the title? Do you think the legal advisor are inside this operational unit, and maybe an example of you saying to some of our guys, our military guys, you know, this is the right things to do, but it will make you a war criminal.
I wouldn't say that. I wouldn't say that it's a right thing to do and it'll make you a war criminal, because usually I wouldn't think it's the right thing to do. But first of all, our system is different than the US, because the legal advisor in the IDF is not subordinate to the commander. Our commander is the military advocate general. We are a separate unit. We have our legal advisors giving the advice to the commanders, but they are not subordinate to the commander. And the military advocate general, he's a general and he's subordinate to the chief of staff in most things, but when it comes to the professional legal advice, he's actually under the, it's not the command, but the one responsible for that is the Attorney General and not the General Chief of Staff, which means that when we say that something is illegal and cannot be done, so the commander cannot overrule us. What the commander can do is go up to the, if it's one of my officers, so they can go up one level to me and try to convince me. If that doesn't work, and go to the MAG. If that doesn't work, it can go up to the ministerial level and up to the prime minister level, even vis-a-vis the attorney general eventually. So it is a bit different. Although in practice, and I have spoke to my US counterparts, and we consult a lot, by the way, in the IDF, our department all the time, with the US legal advisors, military legal advisors, and other UK and other, because we have similar dilemmas. That in fact the difference is not so big, because usually, especially today, if they will say to the commander, look, this is not legal, the commander will not usually disregard that. So the difference is not so big. I also agree, I do agree that what we do say is, first of all, if it's clear-cut, not legal, there are cases where it is clear-cut and that's it, that's the end of the story. Usually, the situation is more to give, as I said, the box. You have a box and you have inside that many possibilities. You have a lot of issues that is a question of consideration. It's a question of reasonableness, which is a flexible term as it is. The whole notion of proportionality, there's no specific formula. So you have to give the perimeter, the outline of the perimeter of what is allowed, the things that have to be considered, but eventually it is the decision of the commander. Mm-hmm. And what we always also do is say these are the legal considerations, this is the legal rule, these are the legal considerations. And then I would say, apart from that, until here this is what you have to hear, I will also, might sometimes also give my opinion on the, as you were saying, on the sensibility of it, on other considerations that should be considered. Once the legal advisors, and here I also accept what was said, the most important thing is to understand, to have mutual understanding. The commanders should understand the law, and the legal advisors have to understand the military situation. Once you have that mutual understanding, they accept also these kinds of insights, like any other officer that is sitting in the room, especially the IDF is very open to hear even low-ranking officers' opinions. You can speak rather freely, so we do that too.
But let's speak about proportionality, for example. Can you really make a case of proportionality? How many civilians should be killed, and it will be okay to kill bin Laden, for example? Or, you know, we have Muhammad death, which is maybe death is deaf or deaf is dead. I don't know what is the correct answer here, but maybe if the IDF was not hesitated so much on legal issue, this guy was long ago dead.
So again, it's not, there's no formula. There are the relevant, considerations that you have to make, and eventually it's a decision of the commander. Now, the higher the level of the person, or if it's military equipment or weapons, or the higher the level or the importance of the system, military system, or of the person, the more what we call military advantage will be gained by eliminating that system or killing that person, and then the more collateral damage, which is the term of including, that can include civilian fatalities even and casualties, other casualties can be still acceptable within and considered legal. What, for example, we can say, you cannot disregard, for example, say, I don't care if there are civilians there. That won't work. Right. Or if it's really extreme cases, that won't work. But if it's the question, if it's 10 people, 20 people, 50 people in certain circumstances, or one person is really an issue that is up to the commander as long as it is reasonable. The standard is the reasonable military commander. That's the legal standard, the reasonable military commander. And I must say that in all the time, that usually the commanders go well beneath this standard, especially in pre-planned kinds of attacks.
Lieutenant General Fridovich, Nina here started it with saying that she doesn't believe there will be a new treaty of war laws. Do you think the laws that are existed today are giving enough space and room for useful combatants in terror, or do you think it should be revised?
I think, I mean, the obvious, it's obvious to me. The reason I said I would come here to speak and to be with you is because I don't think it's sufficient anymore. I don't. I think we've run the gamut of, applying and changing and making them as dynamic and stretching them as far as possible. But every time that happens, once again, as we've talked about and seen over the last day and a half, is we've created more seams and more gaps for others to take advantage of. And as that happens, we put our nation and our people at risk. And that's why I believe that this is a fundamental start point for what we know versus what we want in the future. This is about the 21st century. Every time, America is an example, every time, and I don't know why we're so late to figure this out, but every time we have a strength, and this is part of asymmetry, every time we have a strength, the enemy does what? Ignores the strength and goes to a weakness, a place that we're not either there, or we're not occupied, or we don't have a means to respond immediately. And that's the nature of the beast right now. You've been living with that for the last 40, 50 years. I mean, that's why, I think Americans should come and walk Israel. They should walk Israel and get the feel for what happens here. They would understand. Yeah, I mean, that's what I felt in 2003. I understood the dynamics and how small a place is that has no tactical depth. I used to believe America was your strategic depth, that you can't lose that tie with America. That's being tested these days. We will ride out that storm. We will ride it.
And you think that President Obama doesn't give Israel the strategic depth it needs?
I believe that. I believe the current administration. I'm not a political creature. We're not developed that way. But you're testing my values here, and my values say that I am concerned about the relationship, and it's purely politics. And again, I don't do that, but because I wasn't raised that way as a military officer. But at the end of the day, the reason I'm here is because I believe that you have more than an inherent right to exist. You need to exist. You need to flourish. In spite of everything that's happened, you've continued to flourish. This is a wonderful place.
Professor Jackson, you would...
But I'm greatly concerned. I'm greatly concerned, but I think we'll be okay. The next 18 months, like I said, we'll ride out whatever. But but leave it alone. It'll be fine. But my sharing my concern is like, again, you asked the question. That's why I'm here. I think it's no longer sufficient. There are so many gaps and seams everywhere that again, we've tried to do these things, and we're entrenching ourselves. We're rolling back. We are not the dynamic player we used to be in international, and people have seen that while we might have capability, I don't think we have resolve anymore. We certainly don't have will. So that's need to get on with it.
Before I'm opening the floor to question from the audience, Professor Jackson and Pnina, your short comments on that.
Yes, I agree with Pnina on this. It's unrealistic to expect that we're going to get another treaty on these issues. But also, I'd like to add that if you listen closely the last 2 days, I don't believe that there's been a specific issue identified where it requires a fix in international law. Now, there have been a number of disagreements about that, the interpretation of that law, but there aren't any clearly identified fixes about the language of the law that will resolve those disputes. And it's better to resolve those disputes between us and amongst us than with the entire international community where we'll get so much disagreement about those terms.
Yes.
I
Ms.
just
Baruch.
want to agree. I'm all the time facing this question, the role, this argument, this law is not suffice, the law doesn't allow us, and then I tell people, and I happen to know what the law says in most of laws of armed conflict, not other things, and I say, okay, now tell me what's wrong? What's lacking? And then people say, oh, we cannot target the leaders. I say, but you can. Oh, we cannot do that, but you can. So there's a lot sometimes of ignorance, sorry to say, about in some of the arguments that are made about the lacking and the gaps. And the reason that this ignorance exists is not the fault of those that don't know, it's the fault of the countries, by the way, including the US government, including the other governments that are fighting, and we have been discussing it amongst us, the legal advisors of different militaries, that don't speak up enough about their practice, because practice creates law. And especially when states, and then you have the opinion juris, what we call, when states speak up and explain what they're doing, explain the legal basis for what they're doing, they are creating the law. Now, what happens is that today, the international legal arena is governed by publications written by people that don't come from the from the practice. They come from universities, they come from human rights institutions. They try to enter all kinds of human rights concepts that don't usually fit into armed conflict situations and are not supposed to apply in armed conflict situations in many cases. And this is what you read and this is what you see. And this impacts the understanding of other people of what the law requires. And that's why then they say, okay, you're not fulfilling the law. You're either in breach of the law or that the law is not sufficient to win these wars. But this is not the law. This is their interpretation of the law. And what has to be done is not to make a new treaty, which will never happen, okay, but to explain our interpretation, how all the people sitting here and other militaries, we're not the only ones, the US and Israel, that are worried about this, our interpretation of the law and counterbalance these kinds of remarks. But one last sentence before I open to questions. I want to say just one thing. The law is not the enemy, because I believe that the law and abiding by the law protects us. It defends us, because it's not just security. It's, of course, the basic notion is our security, but it's also our values. And law is a very good safeguard for morality. And if we lose that, we will lose maybe not our existence, but in my view, our justification of our existence.
Thank you very much all for your great and interesting words. And I would like to remind you, before we're taking questions, this is a targeted killing session, so I'm urging you, present yourself, make a question with a question mark in the end, not a statement, and then we'll get a short answer so we can get it all. There is a field guy here and 2 legal advisors, so I urge you to follow the rules. Yes.
My name is Mordechai Kedar. I deal with Islamic ideologies, Islamic organizations, Islamic thought, and so forth. Let me tell you, this is actually directed to Penina and Richard. Why the heck, and this is the question, why the heck should we protect these people with our laws when they do not believe in our laws? They want to destroy our states, our civilization, our law system, our law of war. What some kind of lunatics we are to protect them with laws which they want to destroy, to replace with their Sharia, against our civilization, against our thought, against our culture, and against everything which we believe in.
Thank you very much.
Who created this lunacy, this craziness, to protect them with laws which they do not believe in?
Thank you very much.
I'll take a stab at that. When we got in the mess we were in about torture, Senator John McCain said, "It's not about them, It's about us. And that point has been made frequently by panelists in the last 2 days. I mean, this point can be argued, certainly, but it's important, at least for the U.S. military, to make sure that we are moral human beings responsible to God, which
Got
is
it.
what
Mr.
is
Kedar,
said,
we got your questions.
which was
And you got
said
a
in the
great
Lieber
answer.
Code in 1863, and repeatedly and repeated in as the basis for our laws of armed conflict.
Thank you. Nina?
I think that if we say, okay, we're not abiding by, if we go and kill 100,000 civilians on the other side, according to no law, we say that's our right. Okay, no, yes, that's what we're going to do. First of all, I'm not sure it will win the war. Okay, I'm not sure that if anybody tells me that will win the war. I'm not so sure about that. And I think it will be, in my point of view, losing the war, losing to them, because they want us not only not to exist here, they want to, you said, they want to go against our civilization, against our values, against how we define ourselves. And if we do that, they won the war.
And the law is part of our civilization. Yes, sir.
My name is Simcha Sheldon, and my question is regarding the use of the term non-state actors. When we're talking about countries whose culture of their War Department is to specifically use as a strategy creating terrorist groups that then can hide behind the fictional term non-state actor as a shield so that we cannot properly and potently protect ourselves from them, why is there not an effort to eliminate that fictional creation of non-state actor?
Thank you very much.
Well, the law is, international law is generally based on relationships between states. So the law talks in terms of what state responsibilities are, what their obligations are in the law and in these treaties. But there's substantial law that's been developed over the last several years to talk about what rights states have with regard to non-state actors. So, for example, there was a UN resolution after 9/11 that said that Al-Qaeda had committed essentially an armed attack, that NATO invoked Article 5 of the NATO Treaty of collective self-defense against an armed attack. So there's increasing application of this law that's been developed for relationships between states to non-state actors. And the use of that term isn't intended to, at least when I use it, it's not intended to provide a shield. It's actually intended to be descriptive and to identify the enemy as far as I'm concerned.
Even if they are, the point is that even if they are, there's also, I hear a lot of this argument, let's say that the Hamas is a government of a state and Gaza is a state, and then we can, what? It doesn't make a big difference in what you can do and can't do, at least when it comes to laws of armed conflict. If it is a state on the other side or if it's a non-state on the other side, the differences are minor. When it comes to what you can do with regard to targeting, with your responsibility to the civilian there, that is very limited if it's the civilian of the enemy, supplying, for example, humanitarian needs beyond what is the most essential for preventing starvation, for example, is not required by law, whether it's a state or a non-state. Israel goes beyond that for other considerations again. For example, the idea that it will be worse, we will be worse off if there's also a humanitarian catastrophe for our interest, not only except for other moral considerations. So it won't make a big difference, that's the answer.
Additionally, states don't like to recognize non-state actors as states because it's giving them some legitimacy that the state won't accept. Anytime I talk to nations that were involved in insurgencies, for example, they're not even willing to, some states are not even willing to apply Common Article 3 or Additional Protocol 2 because they say those organizations aren't like a state. They don't get the legitimacy of using force that a state has.
We only have time for one more question. I apologize to everybody waiting. The panelists will be here. We'll be able to talk to them during lunch. but if we don't stop now, we won't get to our afternoon program. Also, after this last question, everybody please wait for a minute. We have some very specific instructions for the afternoon.
My question is really about the American context. There appears to have been a political decision to do more targeted killing by the United States overseas in order to avoid the dilemmas involving detention and interrogation. So sort of exchanging one set of legal questions for another. I was wondering if you could comment on that and whether you think it's appropriate or where you would strike a balance between that.
I said in my opening remarks that there is a capture versus kill analysis that goes into use of force outside of the area of active combat, and that's both a use ad bellum consideration and a policy consideration that is focused on this issue. But it's also focused on the intelligence point I made previously. The soft guys I've talked to would prefer to go in and snatch over killing because they're trying to roll up that organization. So I don't think that's the calculus that is
But if you
happening.
make them, if just a question, a side question on your behalf, what about drones? Where you don't have the capture kill, it's expressly to go in.
Yeah, and the use of drones or any other use of force outside active areas of hostilities goes through the same criteria and analysis. So it's not it's just a choice of means to go after that target.
But you're not capturing.
Right.
Yeah. Maybe we need a new application of the Israeli mind of a drone that can capture.
There will be autonomous systems sooner or later that will allow that.
No, you define the target, and then you figure out how you're going to engage that target. And so you have a range of means of doing that. You have an F-16, you have a Pakistani F-16, you have a American F-16, you have a Special Forces team, which you have to insert in a country that is very dangerous and where you may not be able to get to the target. And so the use of a drone is a lawful means to engage a lawful target.
Well, thank you all very much. I think we can speak more and more about it, and it's a good sign. It was a good conversation. Thank you for Professor Richard Jackson. Thank you for Lieutenant General David Fridovich.